take a deep breath and decide that you are going to stay with me till the end of this presentation. We are discussing the rule of interpretation, and today is the first rule that we are going to discuss, that is the literal rule of interpretation. Whenever we are discussing about any rule of interpretation, we have two parts in it. One, the theory related to that rule. The second one, the case laws. Remember, case laws are the most important aspect from any rule. It is the case clause from where such rule came, or it is the case clause where these rules are applied. So the case laws are heart of the entire discussion on the rules of interpretation. Now, for example, in this presentation, I have two slides to explain what is literal rule and other aspect, and then I have as many as 14 case laws. And for the first time, I have used charts to explain the case laws because case laws are the hearts of any rule of interpretation. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of interpretation of statutes, from today we are going to understand rules by one, and these are very important subjects. Not taking much of your time, let's get into the first slide. Let us start the discussion with the meaning of literal rule of interpretation. This rule has several names, and I am going to give the details of those names in my next slide, but for now, let us try understand the meaning. Let us directly get into my chart. Let's read that chart as is, and it says, while reading a statute, the words used in that enactment or the statute should be interpreted in its natural, literal, grammatical, and ordinary meaning, as long as such words are plain, clear, and unambiguous. That means in any statute, if the words used are plain, clear, and unambiguous, the court shall interpret such statute in its natural, literal, grammatical, and ordinary meaning only. Now you might be getting a question that why so? Why literal rule of interpretation? The reason behind the literal rule of interpretation is, who is making law? The legislature is the one which makes the law. It is the right and liability of the legislature to make laws. And when legislature make laws, it knows the intention of that particular law. Now, when it knows the intention of that particular law and the same is expressed in a plain, clear, and unambiguous words, there should not be any interference from the judiciary on those plain, clear, and unambiguous words, and it should be applied in natural, literal, grammatical, and ordinary meaning only. Saying so, there are exceptions if the words are inconsistent, or if they are incomplete, or if there is lacunae available, or if they are ambiguous. In that case, there is opportunity for the court to interpret. That we are going to understand in different other rules, but for now, we need to understand that the words in an enactment or of a statute should be interpreted in its natural, literal, or grammatical and ordinary meaning only, as long as such words are plain, clear, and unambiguous. I hope that's very clear. With that, I am taking you to next slide where we will see the different names, etc. And here is that slide with different names. What are the reason for this rule and what else we should know? First thing, let us try understand the different names. The first name, literal rule of interpretation, because we are reading it in literal sense. That is why a statute read in a literal sense is being applied under literal rule of interpretation. The second one is grammatical rule of interpretation. We are reading as is, so it is also known as grammatical rule of interpretation. The third one is ordinary rule of interpretation, because this is the most applied rule and this should be the most applied rule. That is why it is also known as ordinary rule of interpretation. This rule is also known as safest rule of interpretation because the judiciary is implementing the statute as is given by the legislature. So both legislature as well as judiciary is safe with this rule. So we are calling this as safest rule of interpretation also. The 5th, 6th and 7th are saying first rule of interpretation, primary rule of interpretation or natural rule of interpretation, because this is the rule which will be first applied by any court whenever they are interpreting any statute. That is why they are called in this name also. This is also known as strict rule because this should be the first rule which should be followed by any court. That is why it is known as strict rule, because here the role of the court is to implement the legislature as is. So it is known as strict rule. The 9th one is popular rule because this is the most used rule, because first the court tried to interpret via this rule only. That is why this is popular rule also. The 10th and 11th, that is litera legis and litera script, which means literal interpretation. These are the different names that we have for literal rule of interpretation. The next question, why literal rule of interpretation? Because we all should always remember that law making is the power of legislature and the court role is only to the extent of declaring it. Court should not try to intervene in the intention of the lawmaker when the words used in a statute is plain, clear and unambiguous. That is the first objective. Now, the role of judiciary is to explain the law, and judiciary should explain law as is. Judiciary should always try to give life to the intent of the lawmaker, not its intention. So it should always focus on giving life to the intention of the lawmaker or the author. So this theory plays a very important role. And interpretation is allowed only when there is no clarity or there are ambiguous parts are available. Unless and until the interpretation or construction is not allowed or supported or appreciated, and this is the last option. It should not be the first option of the court to interpret or construct. So that is why this rule is there, and interpretation is almost done by the maker in interpretation section. When we discussed internal aids of interpretation, we discussed about section 2, which is mostly of interpretation section, where the law will try to give the meaning and definition of those words which are repeatedly used. So interpretation should be done with the help of that section only, and unless and until everything is clear, court should not get into the business of interpretation or construction. Only when there is some confusion, no clarity or ambiguous terms are there, court should get into the business of interpretation. Otherwise, it should be always literal rule of interpretation. That means see it as is. The last box, there I have discussed about what else should we know when it comes to literal rule of interpretation. The first two things, if the law has given broader meaning to a particular word, it should be seen in that way only. On the other hand, if a word has been given a narrow meaning, the court has to see the narrow meaning only. And every word should be seen in its ordinary and natural sense. And also remember that every word shall have meaning. And court should not try to add anything or omit anything under this rule. This is few other things that we need to know. Now comes the bigger part. Let's get into the world of case laws. Before getting into the discussion of our first case law, I would like to share the list of case laws that we are going to discuss in this presentation. There are as many as 14 case laws as I told in the introduction, and here I am going to discuss the facts of few case laws, and under few case laws I am going to discuss only what was held based on the requirement for this particular subject that we are studying now. Besides the list of that case laws, you can also see few interesting images like prawns, beetle leaves, gold, Supreme Court of India, bus stand, a happy politician, sugar cane and a banned book. What are these? Now few girl students maybe started thinking of the design of that bangle. Don't get into there. We are going to understand the relevance of these images when we are discussing the case laws. These are connected to the case laws that we are going to discuss. And at the end of this presentation, I will again bring this sheet and try to connect the images with the case laws. That is the assignment we are going to do at the end. But for now, let's get into the first case law. The first case law that we are understanding here is MAQBOOL HUSSAIN versus State of Mumbai. The details of this case law is available in the next slide in the form of notes, but for now let us try understand the story of MAQBOOL HUSSAIN versus State of Mumbai. MAQBOOL HUSSAIN, an Indian citizen, travelled from Jeddah to India via flight and he landed in Santa Cruz Airport, Mumbai. When the customs authority of this airport checked Mr. MAQBOOL HUSSAIN, they got 107.2 tola of gold which was illegally carried by MAQBOOL HUSSAIN. Now the gold was confiscated under the Sea Customs Act and there was a complaint also registered against MAQBOOL HUSSAIN under the Foreign Exchange Regulation Act. Now MAQBOOL HUSSAIN got concerned. He thought, I have made one offense but I got two punishment. One, they have confiscated my gold. Two, they have also registered a complaint, which means they are going to start a trial against me. So he thought it is double jeopardy. Under Article 20, Clause 2 of Indian Constitution, no person shall be prosecuted and punished for the same offense more than once. So he thought that way and he approached the High Court of Mumbai. Then the case came to the Supreme Court of India where 7-judge bench of Supreme Court discussed the language under Article 20 Clause 2 of Indian Constitution and it was held in this case law that Sea Custom Authority is not a court or a judicial tribunal and the confiscation is not penalty. So whatever they have confiscated, they are not a judicial body or it is not a court and it is not a penalty. So they just confiscated the gold which was illegally carried. But who is going to conduct the trial? The trial will be under Section 8 of the Foreign Exchange Regulation Act and that is the only judiciary action which will be taken against his illegal act. So that way the language of Article 20 Clause 2 which says no person shall be prosecuted and punished. Now the prosecution is happening only once, that is under the Section 8 of Foreign Exchange Regulation Act and punished on that particular section only, but not under the Sea Customs Authority Act because there was only confiscation of illegal good. So that was the judgment and MAQBOOL HUSSAIN got trialed under the Section 8 of the Foreign Exchange Regulation Act. That is the story where Supreme Court said that the Article 20 Clause 2 need to be applied in the literal sense only. The article says no person shall be prosecuted and punished for the same offense more than once. That is prosecuted and punished. But here there was no prosecution under Sea Customs Authority Act. So that is not double jeopardy. For the purpose of notes, I have given additional details here. Read it because there was opportunity given to MAQBOOL HUSSAIN also to take back the gold by paying 12,000 rupees fine, etc. Lot of other things are there in this slide. Please read through. I am not telling everything to save time. With that, I am moving to the next case law. The second case law that we are discussing here is Motipur Zamindar Company versus State of Bihar. This is a very interesting case law and you are seeing lot of sugarcane images there because this case law is all about sugarcane. Whether sugarcane is a vegetable or not, that is what discussed here. why are we discussing so much about sugarcane being vegetable or not? There was some profit to the appellant by proving sugarcane is vegetable. Why? Because under section of the Bihar Sales Tax Act 1947, the government issued a notification exempting certain goods from the payment of sales tax, including green vegetables other than potatoes, except when sold in sealed containers. Now, if you prove that sugarcane is also green vegetable, you are getting exemption on paying sales tax under this notification. So, the appellant wanted to prove that sugarcane is a vegetable. Now, what is common sense? If I ask you whether sugarcane is vegetable or not, what will be your answer? You will say, no, sugarcane is not vegetable. Because we all know the common meaning of sugarcane, and it was first held in the Madhya Pradesh Pan Merchant Association versus State of Madhya Pradesh, and then it was referred in this case law that the word vegetable in taxing statute was to be understood as a common parlance, that is denoting class of vegetables which were grown in a kitchen garden or in a farm and were used for the table. What are the vegetables? Vegetables are those which are grown in a kitchen garden or in a farm. Now sugarcane is not that, and we never use sugarcane on our lunch or dinner. It is never used on our eating table. So that way it is not a vegetable. It is a commercial product, and hence it is coming under the purview of sales tax, which is what held in this particular case law. The third case law that we are discussing is Municipal Board versus State Transport Authority, Rajasthan. What happened here? The State Transport Authority, Rajasthan wanted to shift a particular bus stand from location A to location B. Now, as required under the statute, they gave an order with the 30 days of time to make any application against the change of location of that particular bus stand from location A to location B. Now, the municipal board contended here that the order gave 30 days time, but we came to know about the order very late. So, the statute need to be read as 30 days from the knowledge of the order instead of 30 days from the order. Now, basically, municipal board wanted to have the term the knowledge in that particular understanding. But the Supreme Court held that literal interpretation must be made and hence rejected the application as invalid. It said if the legislature wanted to keep that knowledge part in that particular section, it would have added it. As there is nothing mentioned in that particular section, we should see it in literal sense only, and it is not whether you know or not, the order has been given, you had 30 days time. If you have not made any application against the change of the location of bus stand, now you cannot say that we were not aware. That is what held here. The fourth case law that I am referring here is Robert Wigram versus Richard Spooner. Here I am not discussing the facts of the case. Here it is very important to understand what was held in this case law. It was held that the rule in constructing an act of parliament is to take the words in the sense the legislature has used them, and they are to have that effect unless the construction of those words is either by the preamble or by the context of the words controlled or altered. Basically, it says implement the statute as is. With that, I am moving to next case law. The fifth case law that we are discussing here is RAMAVATAR versus Assistant Sales Tax Officer. This case law is similar to Motipur Zamindar Company versus the state of Bihar. Only two difference that you need to remember here is there the Sales Tax Act is different. Here it is different. Please read in the slide. And the second one, there it was contended that sugarcane is a vegetable, and via saying that they tried to take the exemption for sugarcane, and here instead of sugarcane it is the betel leaves which were discussed. Now the definition of vegetable was again referred from the Madhya Pradesh Pan Merchant Association versus the state of Madhya Pradesh. So that way this case law is quite similar with Motipur Zamindar Company. So you can read them together. Only difference, as I said, the axe and the sugarcane and betel leaf, the subjects. Otherwise, these both are same case laws. The sixth case that we are discussing is Ranjith Udeshi versus State of Maharashtra. Ranjith Udeshi had a book stall and he was selling different books, and one day he got caught by the police for selling an obscene book or a book which is banned by the government of India. Later, he got convicted under IPC section 292, and Ranjith contended that to consider anything as crime, there need to be mens rea as well as actus reus. Now, of course, actus reus is available. I have sold a book, that is an act. But I never had any intention to sell an obscene book. I was not aware that it was an obscene book or it was banned by the government of India. As there is absence of mens rea, it should not be considered as crime. That is what Ranjith appealed and contended. Then it was decided by the 5-judge bench of Supreme Court that knowledge of obscenity is not an essential element under section 292 of IPC. It is not asking for any knowledge, etc. The said section is plain and unambiguous, hence court shall consider the natural meaning, and hence he got convicted and punished accordingly. The seventh case law, that is in Dunlop India and Madras Rubber Factory versus Union of India, it was held that when a word acquires a particular meaning in the trade of commerce circle, that becomes the popular meaning in that context and therefore should be normally accepted. That is what held here. With that, I am moving to next slide. The eighth case law that I am discussing here is Ranjith Singh versus Bejnath Singh. This is a very interesting story. This happened after the Amethi election result. Now in the election, Ranjith Singh won. Now after losing, Bejnath Singh and few other candidates went to election tribunal and said that Ranjith Singh spent more than the permissible election expenditure under the Representation of the People Act 1951. Listening to them, the election tribunal set aside the election result. Ranjith Singh got upset by all this progress. Now he appealed to the Supreme Court of India, and his contention was, I have never crossed the permissible election expenditure under the Representation of the People Act 1951. Yes, there was lot of people behind me. Yes, there was lot of expenditure made. But remember, the people who worked for me as volunteers were the employees of my father, and whatever payment was made to them were the salaries paid to them by my father. I have not spent anything above the permissible election expenditure. Now here, Supreme Court applied the grammatical rule and Ranjith Singh won the case. Supreme Court said, it is not our duty to see what is right and what is wrong. Yes, his father's money can be seen as his money also, but grammatically the statute is very clear. The intention should be taken from the statute itself, and if that needs to be corrected, it is the duty of the legislature. But the court's duty is to apply the statute as is, and hence whatever Ranjith Singh said is right, and that's how he won the case. The next case law that I am referring here is Sterling Foods versus the state of Karnataka, where it was held by the Supreme Court that after processing, that is cutting of heads and tails, peeling, deveining, cleaning and freezing of shrimps, prawns and lobsters, they will not become a different commodity. That is what held here. The next case law, that is State of Punjab versus Inder Singh, it was held that the meaning of term deputation should be understood as under service law and not to be searched under dictionary, because under service law there is already a purview available for the term deputation, and that is what need to be implemented as it is the intention of the author or the lawmaker. The literal rule of interpretation was also discussed under Bhavnagar University versus Palitana Sugar Mills Private Limited, and it was held there that it is the basic principle of construction of statute that the same should be read as a whole, then chapter by chapter, section by section and words by words. Their intention to say that is we have to find the meaning of a word of a particular statute from the statute itself. The next case law, that is State of Kerala versus Mathal Varghese and others, is a very interesting case law of counterfeiting of dollars. Now they got caught under section 489A and 489C of Indian Penal Code, but here the accused said that we have not counterfeited Indian currency and these sections are about the Indian currency. Now both the trial court as well as High Court of Kerala acquitted the accused. But the Supreme Court set aside the judgment of trial court and High Court and said the section has not limited to Indian currency and liable to be punished and to read the currency as under Indian Paper Currency Act 1822. Here Supreme Court also said if we are reading section 489A and 489C as Indian currency only, which is not mentioned in the section as such, even if we are understanding that way, in that case Kerala will become the place for counterfeiting of the currency of different nations of the world. So that is what commented here. The last case law that I am discussing here is Lieutenant Colonel Prathipal Singh Bedi versus Union of India, where it was held that the legislature applies its mind while making any legislation and the court need to consider them as correct expression, and unless and until there is any ambiguity available in the language of the provision, court should not get into any kind of interpretation and just do the literal interpretation of the statute. That is what held here. That brings an end to our discussion on the literal rule of interpretation, and as I told, I am showing this slide again. Now you can read the name of the case law and try to connect the image available there. Now for all the case laws there is no images available, but whatever is available, try to connect them and try to visualize, try to memorize, so that you can bring, if there are any problems in the exam, you can connect these images and then write the case laws. That's why I made this exercise, and with that I am handing over this to Nishan.
Nature is the beautiful gift that God has given to us at free of cost. So please take time to enjoy the beautiful